accused at this point.
Okay, thank you. Mr. Chate?
Thank you, Your Honor. I've already asked for a social worker visit for Miss Hinton to help her with housing. She requested that herself. My client is 70 years old. She's been living in Georgia for the past 50 to 55 years, so she's been here for a very long time. She is a high school graduate and she studied briefly at Penn State University. She said she studied the natural sciences, but I'm not sure how long she was there for. Currently, she's retired and she is on Social Security. Given those factors, Your Honor, I ask the court to consider a signature bond, and I don't object to the state's other conditions.
Um, but you are inclined to allow for a social worker visit?
Yes, Judge.
All right. Bond is set at 500. It's a surety bond. We'll need a social worker visit, and if she does make bond, please be sure that she stays away from the Texaco gas station at 4430 Flat Shoals Road. Thank you.
Number 7, Ms. Miller.
Oh, her next court date is going to be April 29th.
Thank you, Judge.
Thank you, Maxwell. That was Miss Miller.
Yes, ma'am.
Okay. Bianca Miller is accused of 3 counts, excuse me, 4 counts of simple battery from 25 CR 2002H. Ms. Miller, you've been advised of your right to remain silent. Your attorney is going to be Mr. Chate. Mr. Howard? I'm sorry, Mr. Howard? You're on mute.
The phone rang. I'm sorry. Who are we on?
We are on position number 7, Miller, Bianca Miller.
Miller. First arrest.
Okay. Mr. Scirocco? Yes, sir.
Thank you, Judge. This incident took place February 10th, 2025. So this is a delayed arrest at 4245 Cascade Road, Southwest in South Fulton. It's the Indelible Impression Learning Center. Law enforcement was notified on February 14th of a possible physical assault case between a daycare teacher and students there. The assistant director, a Miss Donya Cockrell, Donya Cockrell, had observed the incidents in real time via surveillance monitors in the office. On the 10th, she saw the defendant snatch a young Boston Hightower up by his arm and forcibly shove him in a chair multiple times. While waiting for the director to arrive, she observed the defendant aggressively touching other children in the classroom, including the other victims in this case, Isabella Jeter, that's Jeter, Ethan Saracen, Serracin, and Riley Head, Riley being spelled Ryle. All these children were roughly 1 year old at the time. The defendant was the only teacher in the classroom with approximately 6 to 7 other 1-year-olds in the classroom. The school's policy is, to limit placing hands on children, but if necessary, to just place a hand flatly against their backs to guide them where they need to go. But this is clearly not what happened here. The incident was ultimately reported to DFACS, and she was, I believe, terminated for this. We have made contact with the families of the victims in this case. Miss Atia Hightower, I hope I'm pronouncing that correctly, mother of Boston, confirmed the events in the warrant, and she's since pulled her son out of school and doesn't intend to return him there. She's okay with no contact. We've spoken with Miss Amanda Jeter, mother of Isabella, who explained that her daughter still attends the school, and she wasn't aware of any prior issues with this defendant before this incident. She's okay with no contact as well. We didn't get into any substantive conversation with Mr. Saracen's mother, Crystal. But we did speak also to the mother of Riley, Miss Brandy Head, who confirmed the events in the warrant and explained that she never had any issues with the defendant prior to this, and that her daughter still attends the Learning Center. We would ask the court sound for the families of these victims when appropriate. I believe a few of them may be online here today. The state's bond recommendation, given the sensitive nature of this case, the vulnerable victims here, the multitude of victims here, the state is recommending an $8,000 signature bond through pretrial services for her to complete anger management, to have no further contact with the following victims of their families: Boston Hightower, Isabella Jeter, Ethan Saracen, and Riley Head, to stay away from the Indelible Impression Learning Center at 2445 Cascade Road in South Fulton, that the defendant have no unsupervised contact with minor children that are not hers, and no drugs, weapons, or alcohol while out on bond.
All right, let's see now. Anyone from the Head family, Jeter family, Sarensen family, and Hightower family, if you want to address this court, please unmute
don't
and start
talk.
your video. Please unmute and start your video. Any adult person from the Jeter, Sarensen, Head, or Hightower? Yes, the person,
Hello.
the Evan SA3. What's your name, please?
Yes, hi, my name is Atia Hightower.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes,
Since the incident, has Bianca Miller attempted to communicate with you or any other family member, including
no,
your children? Okay. And do your children still attend Indelible Impressions?
no, it is not.
All right, please mute your screen. Thank you. Is there anyone else from the Jeter, Sarensen, Head family? No, okay. Mr. Chate, any objection to the bond?
No objection, Your Honor.
All right. On each count, it's going to be 1,500. That's going to be a $6,000 signature bond through pretrial services level 1. No further contact with any member of the family for Head, Jeter, Sarensen, and Hightower. She's not to contact the parents and or the children of these particular families. And she's not allowed to work in any location where there are individuals who are under the age of 12. So, Ms. Miller, please remember that if you intend to seek employment, there cannot be any individuals under the age of 12, either attending or otherwise being there on a daily basis. Your next court date is going to be sent to your current mailing address. No illegal drugs, no alcohol, and no weapons. And you're to report to pretrial once a month. Thank you.
The next person is number 9, Ms. Morris.
Ms. Rita Morris is case 25 CR 2001F, accused of battery, family violence, simple assault, family violence, and cruelty in the 3rd degree from April 15th of this year. Ms. Morris, you've been advised of your rights, and your attorney is Mr. Chate. Any priors, Mr. Howard?
Second arrest, 04 ag assault, no bill.
Okay. Ms. Dunlap, yes.
Thank you, Your Honor. This incident location happened at 3204 Spanish Trail Southwest. The victim in this case is Audrey Hall. Officers responded to a domestic dispute at this address. They met with the victim, Mr. Hall, who stated the mother of his child and his girlfriend, the defendant, threw a mug at the back of his head. Officers observed injuries on the victim, damage to the wall where she threw the mug, as well as coffee stains on the wall. She did all this while holding their minor child, initials A.H, and she also brandished a knife at him standing in the kitchen at some point. Our officers did speak to the victim. He stated that they are in a relationship. They live together at the incident location. They share one child. Confirmed the events in a warrant. Stated the defendant did take the knife out of the caddy and held it in her hand, but she never came towards him with the knife or swung it. He stated they've had altercations in the past, but it's the first time police have been called. He only called the police just to document the situation and stated that he's not in fear of the defendant and wants to continue contact. Victim wants defendant to return to the residence and he will be on Zoom so we can sound for Mr. Hall when appropriate. The state is looking for a $3,000 surety bond in this case. Family Violence Intervention Program. No further violent contact with Mr. Audrey Hall. I did recommend a stay away just because this just happened 2 days ago to try to give a cooling off period. No drugs, alcohol, weapons while on bond.
Audrey Hall, if you want to contribute to the proceeding, you have to unmute and start your video, or at least come before the video. Mr. Chate?
Thank you, Your Honor. I'd like to ask the court to consider a signature bond. My client is 40 years old. She's lived in Georgia her entire life. She is a graduate of Southside High School, and she's had a very stable employment history for the past 20 to 21 years. She has worked as a custodian at Hartsfield-Jackson International Airport. My client also informs me that the apartment is in her name. It's her home, and she also informed me that she wants to be with her 3-year-old son. For those reasons, I asked the court to consider a signature bond, but if the court's not willing, then for a surety bond in the $1,000 to $2,000 range.
On the battery is going to be 2,000. The simple assault is 1, and the cruelty is 1. Total bond is 4,000. Signature bond through pretrial services, level 2. There shall be no further contact with Audrey Hall. And if Mr. Hall does not live at the premises, then she can return to the 3204 Spanish Trail Southwest location. But if Mr. Audrey Hall still occupies the premises, then she can return one time only with a police officer to retrieve her child and her property, and she has 30 days to update the court with a new address. She's not allowed to have any contact with Mr. Hall, and she's not allowed to live with Mr. Hall. If Mr. Hall is not on the lease, she will need to file the appropriate dispossessory action to have him removed so that she can return to the property. Within 30 days of being released, she will enroll in a domestic violence intervention program. And these are 26 classes that she will have to attend every week at her expense without missing or skipping any class. Next court date will be sent either to the Spanish Trail location if she's living there without Mr. Hall, or to her new address, which she'll need to provide to the court within 30 days of being released. Thank you.
Position 2, Ms. Brooks.
This is State versus Janice Brooks, accused of accused of failure to have license on person and failure to obey traffic signs, signals, and markings from April 15th of this year, case 25 CR 2003J. Ms. Brooks, you've been advised of your rights, and your attorney is going to be Mr. Chate. Any priors, please?
19. Blunt, you know what the felony bond was?
Oh, no.
Last arrest was 2017, ag battery dismissed, 2010 battery PTI, 08 probation. I have to find out what it was.
All right. Ms. Dunlap?
Thank you, Your Honor. I'm sorry, this is Janice Brooks, correct?
Janice Brooks, yes.
Janice Brooks, sorry. Okay, this incident date happened yesterday. This was a stop on I-78 West and 10th Street. Officers pulled the defendant over for running a red light. They asked her for a license. She responded she didn't have it, but it was valid. They ran her name and date of birth, which came back for, I think it's 6 warrants out of Alpharetta. They also found marijuana, cocaine, and cigarettes in her car. The state is looking for a signature bond through pretrial. I'm not, Mr. Howard, can you confirm she has open warrants in Alpharetta? Because if anything, we would be okay with releasing her to those.
I have to check.
Okay, thank you. No driving without a valid license, and no drugs, alcohol, weapons while on bond.
Total bond from felony court today was 25,000.
It looks like maybe those were the warrants. I don't see the any holds from Alpharetta.
Okay, so those are probably the warrants. Yeah, so signature bond through pretrial would be correct, Your Honor.
Okay. On the failure to have license on person, it's going to be 250, and failure to obey traffic signs, signals, and markings is going to be 1,250. Her total bond is going to be 2,000. So signature bond through the jail. Her next court date is going to be April 29th, unless she posts bond on her other felony case. She'll need to maintain a current address with the court. No driving unless she has a valid driver's license attached to her person at all times. Proper registration and adequate insurance. Thank you.
Person is number one, Mr. Bell.
What was that bond?
2,000 signature bond through the jail.
What was the bond for each charge?
Count one, failure to have license is 250. Count two is 1,250. Signature bond through the jail.
This should be 1,500.
Oh, yeah, you're right. Thank you. I don't know why I was thinking of 750. Okay, you're right. 1,500. Thank you, Mr. Jordan. All right, courtroom two. I'm sorry, who do we have?
Position one, Mr. Bell.
Mr. Bell, thank you. This is Jordan Bell, accused of theft by shoplifting from April 14th, 2025, case 25 CR 1990E. Mr. Bell, you've been advised of your rights, and your attorney is Mr. Chate. Understand this is his first arrest. Anything else, Mr. Scirocco?
I do have a prior arrest, Judge. I have a arrest for robbery in 2013. I don't know what the disposition was for that. It does appear to be a juvenile arrest.
Okay, so we'll just go with adult arrest then.
All right.
And what do you recommend?
The state's recommendation here is a signature bond through pretrial services. A stay away from 2641 Main Street in East Point, and no further contact with Mr. Malik Hussain, MALIK HUSSAIN, and no drugs, weapons, or alcohol while out on bond. This was a theft by shoplifting case where the defendant exited the store with various food and drink items and admitted that he had taken them. He didn't have the money to pay for them.
Okay,
So that's the state's recommendation. Thank you.
thank you. Mr. Chate is going to be a $1,500 signature bond through pretrial services level 1. He reports to pretrial once a month. Stay 200 yards away from the food mart at 2641 Main Street in East Point, and no further contact with the employees of that store, including Malik Hussain. His next court date will be sent to his current address. If he gets arrested again or fails to show up, this bond will be surrendered. Thank you.
Number three, Harris.
State versus Brian or Breon Tiari Harris. Mr. Harris is accused of simple battery, family violence, and criminal trespass from April 15th of this year, case 25 CR 1991H. Mr. Harris, you've been advised of your rights. Your attorney is going to be Mr. Chate. Any priors, Mr. Howard? 8
on probation out of Rockdale for robbery. That was a juvie conviction, but they gave him like 18 years probation in 2017. Also on probation, possession of a firearm by convicted felon, 2 counts. Got an open case out of Alabama, possession of marijuana and larceny, 2019 probation violation.
Thank you. Mr. Scirocco?
Thank you, Judge. This incident took place yesterday, April 14th, at 262 Arthur Langford Jr. Place, Southwest in Atlanta. Law enforcement responded to a domestic dispute call there, and upon arrival made contact with the victim here, Miss Jasmine Mathis, who explained that during an argument with the defendant over the whereabouts of her cell phone, he snatched her glasses off of her face, breaking them in the process. He admitted to breaking the glasses, but stated he had picked them up off the floor after they'd fallen off her face. The two are married. They live together at the residence and they share a 1-year-old child together. The defendant was arrested on scene. That 2022 robbery conviction, it may have been 18 years probation. It was amended because it was amended from an armed robbery, and is what it looks like here. There was a Noel Prost ag assault as well. And I'm not sure if I heard it, but conviction for receipt, possession, transport of a firearm by a convicted felon. That was 2022, 2 counts of that. But we have spoken with the victim in this case. She and the defendant are married, live together, and share 2 children. She corrected. She's confirmed the events on the warrant. She stated this is not the first time the defendant's been violent towards her, but it is the first time she's called the police. She's stated she's okay with no further violent contact, but stated that she is unsure of how the defendant will react now that he's been arrested. We do have an issue with no further violent contact. We'll be asking for no further contact. When asked, how we could help ensure her safety, from the defendant, if he's angry about being arrested, she didn't know, is what she told us. And she said she's okay with the defendant returning to the residence, but we are not. Given the prior convictions, one looks quasi violent, but more so the fact that this is not the first time the defendant's been violent towards Miss Mathis, and her concern over how the defendant will react now that he's actually been arrested for one of these violent incidents with her. The state is concerned for her safety, and we are concerned over the risk of reoffense here. As such, the state's recommendation is a $2,000 surety on the simple battery family violence and a $1,000 surety on the criminal trespass for him to complete FFIP, have no further contact with Jasmine Mathis, to stay away from 262 Arthur Langford Jr. Place in Atlanta. That's an apartment complex, I believe, and no drugs, weapons, or alcohol while out on bond. We would ask the court sound for Miss Mathis if she's on the line.
Jasmine Mathis, I do see your name on the screen. If you want to tell us what you'd like, this is the time to unmute and start your video. All right, Miss Mathis, can you hear me?
Yes, can you hear me?
Yes, please remove your hat. You're in courtroom.
Oh, I'm sorry.
All right, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I swear.
So you're asking for 2 diametrically opposite things. Number one, you want to have contact with Mr. Harris, but on the other hand, you seem to be a little concerned that he might be angry due to this arrest. How do you resolve this conflict?
I want to have no violent contact with Mr. Harris.
I cannot guarantee that.
Well, yes, I understand. That is just would be, you asked me how would I.
Yeah, but on the other hand, you are concerned that he may turn violent because of this.
Okay. Yes, because I stated that I didn't know how he felt about me calling the police and having him arrested. So I didn't know if he would be angry about it or what. I did say that. But I don't fear and danger for my life in regards to me calling the police about him. So that's why, and I do feel it would be a lot more difficult for us to co-parent, because we don't have a third party to intervene between us and our children.
Are you both married?
Yes, ma'am.
And how old is the child?
He's 2. We have a 2-year-old together, and I'm currently pregnant with our baby that's due May 29th.
Okay, thank you. Mr. Chate, anything else to add?
I'd like to ask the court to consider $1,000 surety bond instead, Your Honor. My client's lived here in Georgia almost his entire life. He's currently in college. He's studying public relations at, I believe it's called Southern Mountain University, if I'm not mistaken. I may have gotten the name wrong. He currently has his own business. He is an entrepreneur. He is a personal trainer. He also works for DoorDash, and he also works for Uncle Greg's Enterprise. It's a construction company, and there he does manual labor like debris removal and landscaping work.
Good heavens, where does he have time to rest?
I don't know,
He's
Your Honor.
like rattled off at least 5 jobs right now. So,
Right. He's very industrious like that.
All
He
right.
tells me that the address is his, and that he lives there alone now. I believe that's what he told me. And right, he has 2 sons to take care of, as well as
Well,
with,
that's
so-
interesting. Jasmine, where's Jasmine? Mathis?
Yes, ma'am, I'm here.
Aren't
sir.
you married to him?
Yes, ma'am. I also live at the residence of 262.
So he doesn't live alone.
Right. Well, in the conversation, Your Honor, that's what I was informed of, but that's not the case, it seems. So,
All right, courtroom 2, please unmute. Mr. Harris, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. If you want to answer my questions, that's up to you. Your attorney might not like it. But my concern is, are you married to Jasmine Mathis or are you not?
Yes, ma'am, I am. And as far as the residence, she does live with me, but I had told him that she doesn't because me and her mother had an agreement that the relationship was toxic, and I'm not avoiding contact because I'm not aggressive towards her. I just understand our relationship is unhealthy, and I don't have anywhere to go. And her mother says she has ample space for her to
So
make.
do you want to live with her?
No, ma'am. I
Okay, that's all I need to know. Thank you. Thank you. All right, Miss Jasmine Mathis, you've heard it from your husband. He doesn't want to live with you.
Yeah. So what can we do about that? Because this is
If you
my
please be quiet, if you please be quiet.
oh.
Thank you. Mute your screen. On the simple battery family violence, that's going to be $1,000 surety. On the criminal trespass, that's going to be a $3,000 signature bond through pretrial services, level 2. So, Mr. Harris, you have a $4,000 split bond. You would have to pay the bond on the simple battery family violence, either out of your own pocket or through a bonding company. Bonding companies charge between 10 to 15% of the bond amount. For the criminal trespass, you'll be on a $3,000 signature bond through pretrial services, level 2, which means that you will report to pretrial services twice a month. You will have no further contact with Jasmine Mathis. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. If you would like to have contact with the child or children that you share with Miss Mathis, that must be arranged to a parent through a third party. So either her mother or someone mutually will have to pick up and drop off the children. You are to stay away from 262 Arthur Langford Jr. Place in Atlanta, Georgia. You are only allowed to go back there one time only with a police officer to retrieve your belongings. And then within 30 days, you are to update the court with a new address. Now, if you go to the location with a police officer and Jasmine Mathis and the children no longer occupy the premises, then you can return to that location. But as your wife, she has a right to the location. That's considered a marital home and marital property. So unless you file a divorce and get a court order to retrieve that home back in your name, right now, she has just as much right to that property as you do. But because of this domestic violence case, you cannot return and live in that location unless she vacates the premises or you find a new address. You are to enroll in a domestic violence intervention program within 30 days of being released. So I'm not sure how you are going to accommodate this with your busy work life, because you're going to have to report to pretrial twice a month, and you're going to have to attend those domestic violence classes once a week for 26 weeks at your expense. No illegal drugs, no alcohol, no weapons and firearms. Your next court date is April 24th. 29th, excuse me, April 29th. All right. Please unmute courtroom 2. Yes, Mr. Harris.
Um, uh, I agree with the terms because I do want her to have somewhere stable to stay. I'll continue to pay the bills and stuff that's there. I don't mind that. It's just as far as the classes, the domestic one, I do agree that I do need that one because it's something internally outside the relationship I feel like would help me. But I just had trouble with the classes I would have to like drop one of my jobs.
Figure it out, Mr. Harris. Because of this incident, life changes drastically, and you have to learn to make changes just as your marriage does.
Yes, ma'am.
Figure it out. You're a grown man.
Mhm.
Next court date is April 29th. Thank you.
Number 4, Johnson.
This is Byron Johnson, accused of willful obstruction of a law enforcement officer and reckless conduct, case 25 CR 1993B, from April 15th of this year. Mr. Johnson, you've been advised of your rights, and your attorney is going to be Mr. Chate. Is that correct? No? Ms. McLeod? No?
I think that's Mr.
Afternoon,
McLean.
Your Honor. My client is Mr. Lowe. Is this Mr. Lowe?
This is Byron Johnson.
No, Your Honor, he's not my client.
Okay.
He said McLean. We can go to Mr. Lowe. See right now. Come on. We ain't got time to wait on McLean.
All right. So we're going to wait on Mr. Is he in the, oh, there he is. He's back.
We can do number 6, Mr. Lowe.
Okay. Mr. McLean will be right back with you.
I'm sorry, Your Honor. I was just talking with Ms. Falk about something we're going to send you in about 45 minutes.
Okay,
about
that's fine.
White from the other day. Thank you.
Good. All right. If you please hold, we are addressing Jaron Lowe, LOWE, case 25 CR 1998E. Incident from April 15th, 2025. He's accused of violating the rules regarding pedestrian in roadway and willful obstruction of an officer. Mr. Lowe, you've been advised of your rights, and your attorney is going to be Ms. Maureen McLeod. And any
5 total.
5
Oh.
total?
Yes.
Okay.
Open case out of Newton County, street gang activity, possession of a pistol or revolver by person under 18 years of age. On probation, Newton County, theft of lost mislaid property, sale of marijuana, 2024 probation violation.
All right. Mr. Skiroka?
Thank you, Judge. This incident took place April 15th, yesterday at Joseph E. Lowry Boulevard, where that intersects with I-20 West in Atlanta. Law enforcement was dispatched in response to a report of individuals, the water boys, attempting to commit theft. Upon arrival, the officer observed 4 male subjects speaking with another officer. And as officers approached, 2 of the males had fled across Joseph E. Lowry without using the crosswalk, headed north. They were pursued on foot while the officers issued verbal commands for them to stop. They did not. Ultimately, one of the fleeing individuals identified as a defendant was apprehended at 380 Legacy Drive Southwest. And excuse me, when the officer interviewed the complainant who called about this Cash App Venmo transfer that he didn't authorize, he offered to give them $5, and one of the individuals, not the defendant, had taken that phone and tried to transfer themselves $500. That individual identified the defendant as being one of the four individuals that were there when the other person, Davion Jackson, had attempted to get that $500 from him. Given the open street gang activity in Newton, I see as well theft by receiving convictions, that was from amended from burglary and purchase, possession, manufacture, distribution, sale of marijuana. He pled first offender to, or he took first offender to that in 2021. And there's also a theft of lost or mislaid property in 2024. Given that, the state's recommendation is $500 surety on each count. Stay away from the intersection of Joseph E. Lowry Boulevard and I-20 West, Atlanta. No drugs, weapons, or alcohol while out on bond.
Ms. McLeod?
Yes, Your Honor. I would ask the court to consider signature bond for my client. He is originally from Atlanta. He actually lives at home with his mother and his siblings. He tells me that it was just a matter that he did not want to have any contact with the police. So when he saw the police coming, he left. But it doesn't sound like he was involved in any criminal activity, and he's not charged with anything other than pedestrian in roadway and alleged obstruction of a police officer. And I believe, based on the warrant, that the obstruction is based on the fact that he left the scene when the police came around, which people sometimes do, not because they're up to anything nefarious, but they just wish to avoid contact with the police.
Okay.
I would definitely ask for signature bond for him, Your Honor. He tells me that he is employed, he has a child on the way, and he really doesn't have a lot of money to pay for bond. Where does he live? He lives
Where does he
in
work? Where does he work? You say he's employed.
Yes, he tells me that he works for his cousin and he also works for a restaurant, a Jamaican restaurant, actually. He cleans up there.
Okay. Courtroom 2, Mr. Lowe, you've been advised to remain silent. If you choose to waive your right to remain silent, your attorney will not be happy with you.
All right,
No, I do not want you to speak about any of this. Do you understand?
I ain't gonna speak about it.
Do not say anything. You have a right to remain silent, and believe me, I can represent you. You should not speak about anything. This is just your bond hearing. This is not your trial.
Okay. On the pedestrian and roadway, that's going to be $1,000 signature bond through pretrial services. On the willful obstructions, $1,000 signature bond through pretrial services. This is a $2,000 signature bond through pretrial services. This is going to be level 1. He's to stay away from the intersection of Joseph E. Lowry and 120 West. If he's driving through, that's fine, but he cannot stop and conduct any work over there. He's not to engage in any occupation that requires him to sell merchandise or services while in the open street area. If he works at the Jamaican restaurant, that would be great. But otherwise, he's not allowed to work in anything that requires him to sell merchandise or sell services like he did with the selling water merchandise on the street. He is subject to a curfew of 6 p.m. to 6 a.m. unless he has work hours scheduled at the restaurant. But other than that, he needs to be home by 6 p.m. to 6 a.m. every day. No illegal drugs, no alcohol, no weapons, and no firearms. If he gets arrested again for anything else, this signature bond will be surrendered. Thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, thank you.
You're welcome, Your Honor.
And that's per judge.
Yes.
We're going back to number 4, Mr. Johnson.
All right, Byron Johnson's been accused of willful obstruction, reckless conduct, 25 CR 1993B, has been advised of his rights. His attorney is Mr. McLean. And Mr. Howard, any priors?
Second, got an open case in Fulton. Possession of a sawed-off shotgun, a rifle, machine gun.
Yeah, okay.
Theft of lost, mislaid property. Possession of marijuana less than an ounce. It's 24 PR 005019.
Thank you. Mr. Scirocco?
Thank you, Judge. This incident took place also yesterday. It stems from the same caller with the water boys. Advised that multiple individuals were harassing people and had taken his phone to send themselves $500. It's that same case. But here, one of the individuals, a description was given of one of the individuals provided by the caller, who was attempting to walk away from the area, sort of like the last case, when the officer tried to make contact with one of those individuals, identified as the defendant later. He immediately fled and ran into an apartment at 385 Legacy Drive Southwest. He had an all black book bag that he was wearing. And while officers were knocking on the door, the defendant exited the apartment, no longer wearing that book bag or the jacket he was wearing previously. A 10-year-old male child at the location had informed officers that the defendant had put a book bag inside of his mother's closet. While detained, but not in custody, the defendant had spontaneously uttered that there was a firearm inside of the book bag. The leaseholder of that residence and the victim here, Miss Victoria Mims, had arrived and advised that the defendant did not live at the location. She then provided the officers consent to enter the apartment. Officers then recovered the backpack with an unsecured Glock 19 9mm in it, which was located near the floor in the closet. So the children could have grabbed it. There was another child in the house as well, a 14-year-old. The defendant was then transported for a show-up identification, and the victim from the 911 call confirmed that he was one of the males present during the initial larceny incident. That 24 PI 005019 case, possession of sawed-off shotgun, felony theft of lost or mislaid property, and the marijuana charge. Those offenses were from July of 2024. And in his order for bond, which was a $10,000 split bond, he was to have no weapons or firearms and stay away from. So he's in violation of that with this case. And he was to stay away from 3 Joseph E. Lowry Boulevard, which is actually the Texaco just a mile down from the street, this intersection that we're talking about here, and even closer to the residence that he fled to in this case. So given that, the state's recommendation is, I mean, I'll say this, our office, as you know, Your Honor, takes firearms cases very seriously. Given that Miss Mims or the 2 young children could have been seriously hurt here, and given that the defendant was in violation of his bond on the felony case, the state's recommendation is $3,000 surety on the willful obstruction and a $7,000 surety on the reckless conduct for a total of $10,000 surety for him to have no further contact with Victoria Mims, to stay away from both 385 Legacy Drive, Southwest Atlanta, and the intersection of I-20 westbound and Joseph E. Lowry Boulevard. Surrender any and all firearms to the sheriff's office, and no drugs, no alcohol, and certainly no weapons while out on bond. That is all.
Mr. McLean?
Thank you, Your Honor. 20-year-old Byron Johnson is from Atlanta. He is a high school graduate, and Your Honor, he has worked at Wendy's and other places. He's very young, 20, so a year of employment at the restaurant is kind of like several years employment for people who are considerably older. We would ask the court to consider the lowest possible bond on this, a signature bond if that is possible, but if it is not, then a $1,000 surety bond. Thank you.
Thank you. On the willful obstruction of a law enforcement offer, that's going to be a $1,500 surety. On the reckless conduct, that's a $6,000 surety. His total bond is $7,500. It is a surety bond. Next court date is April 24. No further contact with Victoria Mims and the members of her family. Stay away from 385 Legacy Drive. Stay away from the intersection of I-20 and Joseph V. Lowry. He'll be subject to a curfew of 6 p.m. to 6 a.m. every day unless he's got scheduled work hours with the Wendy's restaurant. Not sure how to describe this to you, Mr. Johnson, but you're not allowed to have any firearms. You can't have them on your person, near you, in any vehicle you occupy, or in any home that you occupy. If you and the firearms are within proximity of each other, your bond most likely will be revoked and you'll remain in jail in a no bond status. Please keep in mind that the prosecutors are intending to report this to the district attorney's office with regards to any possible revocation. Your next court date for this case is going to be April 29th. Thank you.
Position number 8, Mitchell.
Michael Travell Mitchell's accused of giving false information to an officer from April 15th of this year, case 25 CR 1992A. Mr. Mitchell, you've been advised of your rights and your attorney is Mr. Chate?
Aye.
Oh, Mr. McLean? Okay.
25 total.
Okay.
We would have an open case out of Texas, possession of a controlled substance. On probation and enforcement for robbery, ag assault. And they didn't list the case number. But probation was January 2024, 3 years. 2020 criminal damage to property conviction, 2019 failure to appear. 2018 shoplifting no lows, 2014 assault conviction. 08 robbery conviction.
Okay, thank you. Ms. Dunlap?
Thank you, Your Honor. This incident location was 2725 Sylvan Road. While officers were patrolling that area known for high crime, they observed 3 males standing at the bus stop at 2 a.m. There was no buses running in service at that time. They asked the defendant and 2 other males for identification, to which he first gave the wrong name, date of birth, false spelling of his first name, and then gave the false name LeBron James several times to officers that placed him in custody. The state is looking for a signature bond through the jail on this case. No drugs, alcohol, or weapons while on bond.
This is going to be $1,000 signature bond through the jail. Mr. Mitchell, even though you've got a release bond, please keep in mind that this is still now a new open pending case. You'll be required to show up to court when summoned. Thank you.
All right, thank you.
Number 10, Mr. Rim.
No objection, Your Honor.
Thank you, Mr. Flynn. Is this Michael Reams? Matthew Reams, I'm sorry. Mr. McLean, yeah, okay. Mr. Reams' case is 25 CR 001-995Y, accused of driving under the influence of alcohol less safe from April 14th of this year. Mr. Reams, you've been advised of your rights and your attorney is Mr. McLean. Mr. Howard?
9, 2023 probation, 2022 DUI arrest, 2018 DUI conviction, 2021 simple assault DV obstruction, reckless conduct conviction, 2019 vandalism arrest.
Ms. Dunlap?
Thank you, Your Honor. This incident location is 6120 Old National Highway. Officers responded to a car accident. Looks like there were 3 cars in this accident. They spoke to the defendant who already had slurred speech. They told him to stay inside his car multiple times, which he attempted to exit his car. He started standing in the middle lane of the street. Officers then detained him for safety reasons. They asked the defendant, had he been drinking? He stated yes, liquor. Defendant became irate and started striking his head against the rear window and kicking the interior with his feet. Given he has a previous DUI conviction, the state is looking for a $3,000 surety bond on this case. Mothers Against Drunk Driving program, no driving under the influence, and no drugs, alcohol, or weapons while on bond.
Mr. McLean?
Your Honor, 27-year-old Mr. Reams is a veteran of the Navy. When he got out of high school, let's see, he went to Rockdale High School in Conyers, Georgia. But when he got out of high school, he went into the Navy, served there in propulsion, nuclear matters. I recommended the book to him based on our discussion. He became an electrician after that and works for the situation where if you're a union electrician, you go through the IBEW and very professional, certified track. We would ask the court to consider the lowest possible bond on this matter, $1,000 surety bond, if that's possible.
Okay. Bond is going to be set at $5,000. It's just a surety bond. And I'm going to impose the 10% option if Mr. Reams would like to take advantage of it. The 10% option requires him to pay $500 directly to the jail, and then he will report to pretrial services once a week. He will be on level 3. While he's on released on bond, within 15 days, he will enroll and complete an alcohol and drug evaluation and submit himself to any treatment or counseling as required. He will abstain from all illegal drugs, alcoholic beverages, and not own and possess any firearms, and he'll be subject to random screens for drugs and alcohol by pretrial. He is not allowed to drive any vehicle until further order of the court. Yes, Mr. Remus, you have a right to remain silent. Anything you say in open court can and will be used against you. Of course, like I said, the 10% option will subject you to the random screens and pretrial reporting. However, if you don't want to use the 10% option, you're free to get a bond through a bonding company for the entire amount.
I am having financial hardship as I'm currently waiting for another work order from the local union. And I don't see any possible way that I could pay a surety bond.
All right, then you can exercise the 10% option and pay $500.
And
if this case gets resolved in your favor, you get most of it back.
I have to say here.
He probably, and that's even better than a surety bond.
Next court date will be April 24th. And please remember, no driving until further order of the court. So it doesn't matter what Department of Driver Services does. If you get arrested again and you're operating a vehicle, you could lose this $5,000 bond and end up in jail and no bond.
Yes, Your Honor.
All right, thank you. See you on the 29th unless you bond out.
Your Honor, if I may, Mr. Reams, I'll call your emergency phone number and explain the bond situation to them. Thank you.
Thank you.
Mr. Howard, that was level 3 on the 10% option.
I heard you.
Thank you.
Number 11. Seiko. Okay.
Element Seca is cased 25 CR 1996C, accused of 2 counts of battery against a female who's pregnant. Incident date appears to be April 15th, 2025. Mr. Seca, you've been advised of your rights to remain silent, and your attorney is Mr. McLean. Any priors, Mr. Howard?
3rd, 2020 FTA, 2017 simple battery dismissed.
Ms. Dunlop?
Thank you, Your Honor. Just so you're aware, I did have a chance to contact the cab, and there was a different victim in that battery case in 2017. So this incident location was 798 Tiff Ave Southwest. Officers responded to a call about a male beating a woman. They met with an anonymous waste management caller who stated they witnessed the defendant drag the victim from the driver's side of their Honda, forcibly throw her into the passenger side as she was kicking and screaming. They also witnessed him yelling at the female, to which they intervened. She had multiple bruises and lacerations to her neck, face, and shoulder. She stated to officers the defendant choked her, slammed her on the ground, all of this happening while she is 4 months pregnant. He's upset because she did not get an abortion, and she's accusing him of cheating. The defendant stated that she took his phone and kicked him, in which provoked this incident. The witness provided an account that matched the victim's statement. The victim's name in this case is Liliana Davila Brown. That's Liliana. First last name Davila-Brown. Our office did have a chance to speak to Ms. Brown. She stated that they are in a relationship. They live together at the incident location. She's 4 months pregnant with the defendant's child. She stated they did get into an argument about the defendant texting other women, and stated that she left the residence, and when she came back, the defendant got into the car and began slamming her face in the door and seats. The victim stated the defendant then got on top of her while sitting in the driver's seat and started grabbing her face and jaw area. She stated the defendant then got out of the car, pulled her out of the car, and drove off. She stated a week ago, police were called because the defendant slammed her into the bed and was grabbing her shoulders, caused bruising. She also stated the defendant then began chasing her around outside, and the police didn't arrest him at this time. She stated the police have been called multiple times for other altercations by third parties, but there's never been an arrest made. For the defendant, she stated that she wants contact because she's pregnant and they live together, and she will be on Zoom so we can sound for Ms. Brown when appropriate. Given the nature of the allegations, the state is looking for a $6,000 surety bond, no further contact with Liliana Davila Brown, a stay away from this home address, family violence intervention program, and no drugs, alcohol, or weapons while on bond.
And that address was something Tift Avenue. Could you
I
give me?
have 798 Tiff Avenue Southwest, TIFF.
Got it. Thank you. Miss Ileana Davila Brown, if you're on Zoom, if you want to contribute to the proceeding, this would be the time to unmute and start your video.
Hi.
All right. Did you want to say something?
Yes, there were a
Okay,
few
let me go
things
ahead
that.
and place you under oath.
Oh, okay.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
The information that was provided by the prosecutor, Ms. Tamara Dunlop, do you agree with her, the events she has indicated?
No, there were facts in there that were not correct.
Which one?
Well, my name wasn't spelled right, and also there were I got on a phone call earlier and explained the situation, but they reported that I was dragged out of the car like by my hair and that I was choked, but I was never choked by this person, or like he took me out of the car, but he didn't drag me out by my hair, and he didn't slam me on the ground or anything like that. He was grabbing my face, but he did not strangle me. He just was he was like shoving my face and grabbing my face, and those few facts were just not correct.
So this would not be the information that the officer reported? Because the officer had body cam on him or her, and they would be recording what you said.
Yes, no, I did not report that. I reported that he grabbed my face and that he was grabbing it hard and against the side of the car, and that he took me out of the car and drove away.
Okay. And whose car is it?
My car.
And are you married to him?
No.
Okay. So that's the car that's in your name?
Yes.
Okay. Anything else that you'd like to tell me?
Just that I do have hope for him, and that I see him not doing this again, and that he's working hard to stabilize himself in order for us to have a child. And I feel like that this is very sad and like a step backwards, but that otherwise he is moving forward.
Okay, thank you. All right, Mr. Villa Brown, you may mute your panel. Mr. McLean?
Thank you, Your Honor. 24-year-old Mr. Seca is a high school graduate and works in the construction division or contractor for one of the large regional, actually national home product supply companies. And they have a construction division, so yeah, he does the construction work, not just sell the products. He worked for its competitor, which is also a national chain of the same thing before, and he worked at a large national grocery chain before, and also a large national restaurant chain. So he's very industrious at his age. He's had a lot of jobs, several jobs, but appropriate lengths of time. And we would ask the court to consider the lowest possible bond in this situation. If that is not a signature bond, we would ask the court to consider a $1,000 surety.
Okay. On count 1, battery against a female is pregnant, that's 1,500. And count 2, the second count, is going to be 2,500. This is going to be a $4,000 surety bond. No further contact with Ileana Davila Brown, which means that he's not allowed to communicate with her in person through a third party, mail, email, phones, computer devices, and even on social media. To stay away from 798 Tiff Avenue in Southwest Atlanta. And he's allowed to return to that location one time only with a police officer to retrieve his belongings. And then he's to update the court with his new address within 30 days of being released. No illegal drugs, no alcohol, and no weapons. Next court date is going to be April 29th. Yes, Mr. Jordan, did I do that wrong again?
No, I was just wondering, because I thought they said that the 798 was the incident address, but not the address that they
I've
gave us.
got that as a residential address on the, even on the booking, on the jailing screen.
Okay.
Let me
Just wanted to
see.
make sure.
798 Tiff Avenue. That seems to be the address, home address.
Okay.
So he'll need to change that within 30 days. Once he's released.
Number 12, Mr. Thornton.
This is Dion Thornton, accused of battery from October 12th, 2024, case 25 CR 1999G. Mr. Thornton, you've been advised of your rights and your attorney is going to be Mr. McLean. Any priors, Mr. Howard?
Second, 2021, possession of a firearm by convicted felon or felony first offender. Ag assault, possession of a knife or a firearm during the commission. Those charges were dismissed.
Ms. Dunlap?
Thank you, Your Honor. I had last name as Thomas. Did I write that incorrectly? Dion Thomas?
Dion, I've got it as Thornton on the calendar and also on Odyssey.
Okay, I'll double check that. I just wanted to just make sure it's the right person I was speaking about. This incident date happened October 12th, 2024 at 6220. I am unsure how to pronounce this street, so I'm just gonna spell it Duquesne Drive Southwest. The victim in this case is a Lawrace Roy, Lawrace, last name Roye. Victim told officers while at his job, this is his coworker, the defendant, punched him in his face. He had walked up to the defendant to talk to him about something when he punched him, tried to fight him, to which the victim went and alerted the supervisor. Victim had injuries to his face as well as swelling. They were both sent home pending investigation. Our office did have a chance to speak to the victim. He stated that they were coworkers. There's been issues in the past. It's the first time things got physical. He stated the defendant was saying something to him as he walked towards the defendant. They exchanged words. He turned around and the defendant struck him with a stick, causing a laceration to his chin. The victim also confirmed they were both terminated due to this incident and they have not seen or spoken to each other since the incident. He wants no contact and it looks like he's unable to be on Zoom, but still sound for him just in case he was. State is looking for a $2,000 surety bond in this case. No further contact with Lawrence Roy. 1 day anger awareness and no drugs, alcohol, weapons while on bond. And I guess a stay away isn't necessary since this is a work address.
Is there a Lawrace Roy with a silent E at the end? Roye on Zoom. All right, thank you. Mr. Thornton is going to be a 2,500 signature bond through pretrial services level 1. You report to pretrial once a month. Have no further contact with Lawrace Roy and stay away from your prior employer where this incident took place. No illegal drugs, alcohol, and no weapons and firearms. If you get arrested again for anything else from this point onwards, you risk losing your signature bond. Thank you.
Thank you, Your Honor.
Number 13, Williams.
Jolene Williams is accused of battery from April 15th, 2025, case 25 CR 2000D. Mr. Williams, you've been advised of your rights and your attorney is Mr. McLean. This is his first arrest. Where is, Ms. Dunlap, sorry. Yes, Ms. Dunlap, what's the recommendation?
The recommendation in this case is actually an $8,000 surety bond. No further contact with the victim. Amanda Wisdom, a stay away from 3100 Godby Road. 1 day anger awareness and no drugs, alcohol, weapons while on bond. To briefly put the facts on record, officers responded to a domestic violence call. They met with the victim who was crying and had a bloody nose. She advised that the defendant, who is her partner, is prone to outbursts and aggressive behavior over minor things. He punched her in the face over a social media post, and he ended up breaking her nose. So we did have a chance to speak with the victim. She stated they're in a relationship. They do not live together and they share no children. She confirmed the events in a warrant and stated that the incident location is the defendant's residence. Okay. So what the stay away would it be necessary? She stated that they were in a physical altercation. In the midst of the altercation, defendant punched her in the nose, causing it to break. She stated this is not the first time defendant has been violent towards her and not the first time the police have been involved. This is the first time he's been arrested. She stated that she filed for a TPO, that's 25 CV 005050. She stated she does not wish to have contact with the defendant and she will be on Zoom so you can sound for her when appropriate. We did recommend this as a felony upgrade and we have yet to hear back from the DA's office just to make the court aware.
And that was Amanda Wisdom.
Wisdom, yes, Your Honor, that's what I have.
All right, Ms. Wisdom, if you want to contribute to the proceedings, this will be the time to start your video and unmute your Zoom panel. Okay, Mr. McLean?
Your Honor, he is 23 years old. Mr. Williams is a high school graduate from George Butler High School in Augusta, Georgia. He's been a Georgian all his life. It is correct that Godby Road is his address. I can put in chat the unit number. He noted when I asked him that the address shown in the jail documents didn't show his unit number, and he was afraid he wouldn't get his mail. He works for a large distribution company, one of the nationally known distribution companies. He does the pick and pack work, but he also does forklift driving, managing, and training at that company. So he has been there for a while and has worked his way up a bit. He previously was an assistant manager at a restaurant, and 2 years before that, he worked at one of the coffee stores. And before that, he also cleaned golf carts. And so that's the last 5 years worth of work leading up to his age 23. He would ask the court to consider the lowest possible bond for him, a surety bond if that is possible, and a $1,000 to $1,500 surety bond if it's not.
Bond is set at $2,500. This is a surety bond. Next court date is April 29th. No further contact with Amanda Wisdom, and no illegal drugs, no alcohol, and no weapons. Next court date is April 29th. Thank you. Mr. Williams, please be aware that they are thinking of upgrading this to a felony charge. Thank you.
Add on, Mr. Mitchell, on add-on calendar.
Do we know what's going on with, oh, this is the add-on. Okay.
Miss Jones' bond was posted, if you guys want to know about her.
All right. So this is Daryl Mitchell. Would that be correct?
Yes, it is.
Accused of criminal trespass and willful obstruction of an officer, 25 CR 1989J from April 11th, 2025. Mr. Mitchell, you've been advised of your right to remain silent, and your attorney is Mr. Chatay. Mr. Howard, any priors?
15, 2024 trespass obstruction conviction.
And this is Daryl.
2 more trespass arrests from 2024. Got a 2024 simple assault trespass arrest, 2023 trespass.
Okay.
2021 disorderly conduct conviction, FTA from 2019, and a 2018 simple battery DV to the children arrest.
Thank you. Ms. Allen?
Thank you, Your Honor. This is a bind over case. The date of incident is April the 11th. This took place, this criminal trespass, at the
Texaco?
Yep, 4430 Flat Shoals Road. And that's significant because just February the 25th of 2025, this defendant entered in a plea to multiple cases involving criminal trespass at that same location. He has suspended probation, I believe, terms, but at least 5 cases from the same location with similar conduct.
Okay.
Officers responded to the location based on a call about suspicious individuals on the property. They made contact with the defendant. He was spoken with, his information was verified, and it was confirmed that he has an active ban for a year starting in November 2024. He was again criminally trespassed, and he refused to talk to police or follow verbal commands. He walked away, wouldn't provide his identification. It took them a while to identify him correctly. Ultimately, he was arrested. I do see that he was charged, and we did not receive that charge as part of the bind over for terroristic threats against the officers there on scene. He also has a failure to appear from January. We're asking for a $2,000 surety, Your Honor. There's something going on here. We'd ask for a social worker visit or an order ahead for mental health or substance abuse, whatever the issue is, to stay away from that location, the Texaco, and have no drugs, alcohol, or weapons. Thank you.
All right. Mr. McLean? Oh, Mr. Chate, I'm sorry.
Yes, thank you, Your Honor. My client's 42 years old. He's lived in the state of Georgia since he was 11, so it's been 31 years that he's been here in the state. He went to college for about 1.5 years at Morris Brown College in Atlanta. He studied computer science and engineering there. He's currently self-employed. He has his own music company and he also does auto financing. And he also works for an insurance company. So he's a busy man and he works very hard. He'd like the court to consider a signature bond, but if the court is not willing, then we would ask for $1,000 surety.
One second.
When I look at up this individual and case manager, what I see is multiple convictions as a part of a global plea in October of 2024, followed by multiple convictions as part of a global plea again in February of 2025, all dealing with the same locations.
Thank you. Mr. Mitchell, you've been booked into Fulton County Jail since February of 21st of 2024, released April 9th, you came back on May 16th, released May 18th, you came back on August 20th, came back on October 30th. You were then arrested again on February 11th and took a plea on February 26th. And you were told, do not return to the Texaco. I'm not sure what is the particular attraction, but your bond at the present time is going to be $500 on each count. That's a $1,000 surety bond. And in the event that you make bond, you'll be equipped with an ankle monitor. The ankle monitor fees are about $300 a month, and you will pay that for a minimum period of 6 months. 6 months ankle monitoring while you're out of bond. And you are to stay 500 yards away. That's the length of 5 football fields from the Texaco gas station at 4430 Flat Shoals Road in Atlanta, Georgia. Your next court date is going to be April 29th. You have a right to remain silent in anything you choose to say in open court. Your statements can and will be used against you. You have a right to an attorney. And if you waive your right to remain silent, your statements can be used against you. And your attorney, Mr. Chate, will not be a happy puppy. So
I understand, but it's something that I need to say. It's something that I need to.
Mr. Mitchell, I really advise you not to say anything at this stage. There's nothing you can really say to change the outcome of this bond hearing. This is not a trial and you can't litigate the allegations against you right now.
I understand what you're saying, but it's still something I need to say. I had a bond coming into this. I already had a bond.
yes,
On here.
yes.
That's $700 bond on the 2 counts.
Based on this record history, it's kind of tough when a judge has to review your case over and over again. And the more information we get, the greater concern is that you show a high propensity to reoffend. And given the information I've given you, I'm amending the bond based on your criminal record history, based on your high likelihood to reoffend, and your failure to comply with the court's directive that you stay away from a particular location.
But my last arrest was not at the Texaco. It's a laundromat that's connected to the Texaco.
It is a trespass.
But you know, I understand what I'm saying. The Texaco is 4430, the laundromat is 4438. I was not ever given a charge at the laundromat.
What's the distance between the laundromat and the Texaco gas station?
They're in the same plaza, but they're different addresses. I was working at both of them.
Now you're required to stay 500 yards away from that location, and that ankle monitor will tell us where you've been for the next 6 months.
And I will honor that. I was just making it clear because it sounds like I was at the Texaco and I didn't go back to the Texaco. I was at the laundromat. It's all in one plaza. But I did not go back to the Texaco after I got a court order not to go back. I didn't go back.
And I hope the video footage that they produce will convince the prosecutor accordingly. Thank you.
Add-on number 3, Stafford.
Next court date is April 29th. Damus, D-A-M-U-S, LaVictor Stafford is accused of theft by taking and misdemeanor possession of marijuana. Case 25 CR 1994Y. Mr. Stafford, you've been advised of your right to remain silent, and your attorney is Mr. Chate. Okay. Mr. Howard, how many priors?
28.
28. Okay.
2020 fade to appear. 2019 forgery, 4th degree conviction. 2019 disorderly conduct conviction. 2017 shoplifting conviction. You got some violent charges from 2012 and 09.
Oh, thank you. Miss Allen?
Thank you, Your Honor. This is the last bind over for today. So again, Union City. The incident location is 4617 Jonesboro Road. That's a Walgreens. On the 12th of April, it was reported that the defendant was witnessed by employees there at the Walgreens, taking multiple boxes of personal products, among some other things, and then leaving the store. Employees reported that they yelled at the defendant to stop, to put the items back, and not to leave, and he ignored the request and left without paying. Officers arrived on scene, took a report, and then after being provided the description of the defendant and putting out that information, saw that he had been located nearby at a Chevron station. He was taken into custody and searched incident to arrest, where these items were found on his person, as well as the marijuana that is part of count 2. He made some admissions, but minimized during his conversation with officers. The officers did a show-up ID with the Walgreens staff, and he was positively identified. We're asking, let's see, he came in with a $1,500 bond. We'd ask for $1,000 surety to stay away from that location, no drugs, alcohol, or weapons, and we'd request a social worker visit.
Mr. Chate?
Thank you, Your Honor. I'd like to ask the court to consider a signature bond if that's at all possible. My client is 44 years old. He is a lifelong resident of Georgia. He's therefore, I would argue, a minimal flight risk. He has a GED and he has been attending Atlanta Area Tech. And for 5 years now, he has worked for his uncle. He does home remodeling, home improvement, and he paints houses. For those reasons, I asked the court to consider a signature bond instead.
All right. Under theft by taking is 1,000 surety. And the misdemeanor possession of marijuana is a 500 signature bond through the jail. To stay away from the Walgreens at 4617 Jonesboro Road. Have no contact with the employees and the managers at that store. Next court date is April 29th. So it's a 1,500 split bond. Next case, please.
We're done.
Are we done, courtroom 2?
Yes, we're done.
Okay, Mr. McLean or Mr. Chate, did y'all have any waivers or anything like that? No?
None.
Okay.
No, Your Honor.
Position number 1, Jordan Bell was a 1,500 signature bond for pretrial level 1. 2, Janice Brooks is a 1,500 signature bond through the jail. Reset April 29th because of her pending felony case. Position 3, Harris, that's going to be a $4,000 split bond. And the case is reset to April 29th. Position 4, Byron Johnson is a 7,500 surety, reset April 29th. Position 5, Karika Jones, is that a release? Release, okay.
Officer Blunt said she was released.
Is that correct, Mr. Jordan?
Yes, Your Honor. Officer Blunt said she was released.
All right. Position 6 was a $1,000 signature, excuse me, a $2,000 signature bond to pretrial level 1. Position 7, Miller is a, I think it was a $6,000 signature bond through pretrial level 1. Position 8, Mitchell's $1,000 signature bond through the jail. 9, Morris, that's a $4,000 signature bond to pretrial level 2. Reams, that's going to be a $5,000 surety bond with a 10% option. 11, Secker, that's going to be a $4,000 surety, reset April 29th. 12, Thornton is a 2,500 signature bond to pretrial level 1.
That was no contact?
Oh, yeah, it was no contact with Laurie Roy, the
Okay.
ex-employee with the same place. Jolene Williams is a 2,500 surety, reset date April 29th. Add-on position 1, Hinton is a 500 surety, reset April 29th. Position 2 is a $1,000 surety with 6 months minimum ankle monitor. Position 3, Stafford is a $1,500 split bond. Any changes? Yes? No? Sounds good then. All right, I will see everyone Friday. Take care.
Thank you.
Thank you,
Have a
Judge.
nice afternoon, everyone.
You too.
Your Honor,
Yes?
we'll be in
Oh.
touch with about the Gary White consent bond modification.
Okay, I haven't had a chance to look at my emails, but if you and Miss Allen have something to submit, I'll be glad to look at it.
I think Ms. Falk has probably already sent it to me for
Oh.
review. She'll
You'll
probably
get something shortly, I'm sure.
right.
Okay, if I have any questions, I'll reach out to both you and Miss Falk, okay?
Thank
you so
you.
All right, y'all have a good afternoon. Thank
Thank you.
you. Bye-bye.
Friday.